Here in the appeal of Appadoo against SBM Bank Limited.
Good morning. I appear with a bit of a team this morning from the English Bar, Ms Masood, and from the Bar of Mauritius, Mr Persson, Senior Counsel, and behind me, Mr Suku. Mr Duval, Senior Counsel, is here for Mr Appadoo. The order of submissions this morning on the appeal, I propose to do a short intro and look in summary at the grounds of appeal, and then look at the perversity test as it applies to appeals of fact. I'm going to invite Ms Masood to do a short review of the evidence, to take you through the documents that the Industrial Court looked at and considered, and then I give you my submissions on the analysis of the errors made by the Supreme Court and my reply to what Mr Duval has put in his written case. Then after Mr Duval's submissions on the appeal, I'll make any submissions in reply if there are any, and then hopefully we'll complete that before lunch ahead of the timetable that the parties put forward to the board in advance. And then this afternoon, Mr Duval obviously make his submissions on the cross-appeal, and our submissions in reply on the cross-appeal will be made by Mr Persson, Senior Counsel.
Mr Burns, I can't resist it. On what legal basis do you say the contract came to an end on the 24th of November 2012?
By agreement.
Whose agreement? Whose agreement?
Agreement between the parties, between SBM
Express
Bank.
agreement. Express agreement.
Express agreement.
Who on behalf of the bank agreed with Mr Appadoo?
Well, if I take you to the document, the only document that referred to is at page 393, and you'll see that the bank was represented by its HR manager.
Mr Lutchman?
No, Mr Sunasi.
Who didn't give evidence?
Who didn't give evidence. Mr Lutchman gave evidence on behalf of the bank, not Mr Sunasi.
Who knew nothing.
And what Mr Sunasi did on the 23rd of November is go through the exit procedure with Mr Appadoo.
What are we looking at?
We're looking
Where's
at
the evidence that he was sitting down with Mr Appadoo, with this document in front of him, going through this document with Mr Appadoo?
There's not evidence of that.
Right, okay.
What there is evidence that was, in fact, uncontested before the Industrial Court, that the HR department went through this exit procedure checklist and did a number of things. And what...
don't need to do that in the presence of Mr Appadoo?
No. They don't need to go through the checklist. What they need to do is they need to then do the things that the checklist says was done. And the checklist says a number of things were performed. We see that it's signed at the bottom of the page there by the HR officer from the Human Resources.
What page are we looking at? Sorry.
We're looking at page 393 of the electronic bundle.
The checklist.
Oh, I see.
And what does it mean by saying agreement on last working day not applicable?
So what we have is we have the employee. If I take you through the whole checklist, obviously this is the checklist for Mr Appadoo. Last working day, 23rd November. Date of departure, 24th November.
But surely that's just an assessment by the bank as to what the last working day is. Well, where's the agreement on the last working day?
Well, so what we have is we have a number of things ticked and signed by the HR officer.
But the document doesn't speak for itself. You know, I mean, you need a witness to tell us what was actually done.
Well, that's what the Industrial Court. Obviously, this is a court of appeal rather than the court to decide the facts. The court that should decide the facts heard from Mr Appadoo about what happened on the 23rd and 24th.
This isn't just a question of fact. I mean, for example, the next box is in case of dismissal, non-renewal of contract, formally inform concerned employee. Not applicable.
Yes, this wasn't a case of dismissal. It wasn't a case of non-renewal of contract. which is why I said, in answer to the...
It only come to an end prematurely with Mr Appadoo's agreement.
Yes,
An agreement of, in fact, obviously a mutual agreement.
yes, mutual agreement. So
Where is the evidence of agreement by either party?
what we had was this. We had Mr Appadoo being employed, first of all, for a decade as on an indeterminate contract, so it's not a fixed-term contract. We then had Mr Appadoo employed on a series of fixed-term contracts.
The last one to terminate on the 30th of November.
Absolutely. And what we see is the fixed-term contracts are of 3 years duration or 5 years duration, except for the one which was renewed in 2012. In 2012, what we have is a contract which was renewed just for 6 weeks. It was renewed for 6 weeks in October 2012, ending on the 30th of November 2012. Something then happened. So that we say, the evidence for the industrial court was, something unusual happened in that there wasn't a normal 3-year or 5-year renewal, there was just a 6-week renewal. During that period, the bank went through an exit procedure in relation to Mr Appadoo. And the bank went through a new 5-year fixed-term contract. That was signed on the 12th of December, not to commence immediately, as all other fixed-term contracts had commenced straight away, but to commence in the future, on the 24th of December 2012. So the only natural inference for the industrial court was that on the 12th of December, Mr Appadoo was not in employment, because he signed a contract on the 12th for his employment to start in the future, on the 24th.
Well, it doesn't really matter whether he was in employment on the 12th of December, because that's less than 28 days before the 24th of December. So the critical point is whether he was in employment on the 24th, 5th, 26th, because if it was after that, you don't have your 28-day gap. But in any case, there's nothing unusual, is there, about an employee signing a fixed-term contract to start at a later date if he's currently employed.
That's true, but on nobody's case was he employed on the 12th of November, on the 12th of December.
Is that right?
Because on Mr Appadoo's case, and indeed what the Supreme Court said, in contradiction to the Industrial Court, was that the contract up until the 30th of November continued unterminated. The Industrial Court found that the contract was terminated on the 24th.
Yes, I see. I mean, so on one analysis, the term, I'm assuming nothing had happened on the 23rd, 24th of November.
Yes.
The term would have expired
on the 30th. So he's out of work.
I follow that.
And so on the 12th of December, he signs his new contract to start in the future on the 24th.
Yes.
Plainly, the Industrial Court must have inferred that the reason for starting it in the future was that was the end of the 28-day period of non-employment.
No, well,
Why?
no.
Why do you say
I mean,
that?
it could have been a mistake. The bank made a mistake about the 24th and the 30th. They wrote to the Bank of Mauritius saying that the contract had expired, which is consistent with them thinking it had expired. But they were 6 days early, and they should have made the new contract only start on the 30th of December or the 1st of January.
Well, the Industrial Court found otherwise, and then the Industrial Court is the finding of
Did it?
finding of fact.
I'm concerned
You'll
to
have to show
know which
us the
findings
finding.
of the Industrial Court you do rely
Yes.
on in this connection, because we'll have for consent.
Yes. So the Industrial Court looked at all these matters. I mean, plainly, there was not a consistent evidential documentary record showing absolutely, as the board have pointed out, only one state of affairs, i.e. everything points to there being an agreement for termination effective the 24th of November, because the Industrial
You
Court...
didn't even assert that in your response to his employment claim.
And the Industrial Court, you can see that from the judgment, they say, well, these factors point against a 28-day break in the employment. These factors point in favour of a 28-day. We have to, and the Industrial Court said, we have to assess.
Find out whether or not there was or wasn't an agreement. That's what they
with
should have said.
or a 28-day break in the,
Yes.
between the agreements.
And that requires an agreement to bring the contract to an end early.
Yes, or some termination.
Well, you said you were relying on an agreement when my lord asked you at the outset.
That's right. And that's because
A mutual agreement.
That's because of page 393 and the fact that the HR officer has ticked and then signed that there was agreement on last working day being the 23rd of November. So that is evidence on behalf of SBM Bank that its HR officer did a number of things, which all,
Who
as
is,
you see,
whose
were ticked.
signature is that as the HR officer?
Mr. Sonasi.
Right. And did he give evidence as to...
No, Mr. Lutchman gave evidence on behalf of the bank, and he put this document
But
in
he
evidence.
he couldn't tell the industrial court anything about what had happened or what Mr Sunasi had done.
Well, he did. He purported to tell them that there was a 28-day break in
Well,
the employment.
he said that
He knew
there was a
about it.
standard practice about a 28-day.
No, and he also said that there had been a break in Mr. Appadoo's
What page
employment.
is that?
Perhaps if I can take you through, I've got all these things to come. I wonder if I can come to that. I'll come to it quickly.
Just to alert you, something that concerns me
Yes.
is what we're talking about is what does this legislation, this section in the Act, what does that section mean by there being a 28-day break,
Yes.
to the effect of which is to discount, in terms of the employee's rights, all their previous service.
Yes. So what,
So I hope you're going to address at some point, is the statutory test that the legislature intended this kind of technical test about, well, did the contract come to an end, did it not? Or is it talking about something that is a break in the employment in a true sense as being something which justifies then discounting all the previous decades of service when
Yes.
you come to assess their severance pay?
in my submission, it has to be a genuine break in service. And yes, as you've probably seen from the industrial court's analysis, if you're a worker who earns less than 360,000 rupees, you're protected against breaks of employment in this sort. So it's not lawful for an employer to dismiss on fixed-term contracts. But if you're a employee who's a worker who earns more than 360,000 rupees, you don't have that same protection. And so Mr Appadoo, who earned a lot more than that, was lawfully able to be employed on fixed-term contracts. And when the fixed-term contracts came to an end, he didn't get his severance allowance as of right because he's not an employee, a worker, sorry, below that threshold.
And are there other benefits that turn either statutory benefits or bank benefits? I mean, his pension, that kind of thing. Does that all turn on his continuity of employment as well?
No. What turns on continuity of employment is the severance allowance. And and you may have seen this from the industrial court, the worker rights, work protection for those workers who are below 360,000 rupees prevents employers from a number of things. But other parts of the Employment Rights Act of Mauritius apply to all employees, whether they're workers or not. And so, for instance, the requirement to give reasons in the termination letter, that's a requirement of the Employment Rights Act, which applies to all employees, whether or not they're a worker below effectively a protected worker, if I can call it that, below the threshold, a low-paid worker, or whether they're any sort of employee. So,
Can I just be absolutely certain I understand? You say that there is a break in the employment by virtue of the fact that the contract which was due to end on the 30th of November was ended by mutual agreement. And the evidence you rely upon is, in fact, this hearsay evidence of the HR officer, Mr. Suleiman.
Mr. Lutchman's hearsay evidence, because he wasn't there at the meeting, he reported on it.
Mr. Lutchman relies upon what Mr. Suleiman has recorded, and In my book, that's hearsay evidence.
So Mr. Lutchman relied, yes, he wasn't the person who did it. He didn't say that.
Yeah.
He said he knew about it. He gave evidence to the industrial court of that. And then...
But do I understand you correctly? That is, the contract, which was due to end on the 30th of November, was ended by mutual agreement. That's your case?
Yes.
Yeah. Okay. And you rely, the principal evidence you rely upon is this document?
The principal evidence is Mr. Lutchman's oral evidence supported by this document.
And what possible evidence could Mr. Lutchman give as to a mutual agreement? He wasn't involved in anything.
Well, what he said he was involved with is, first, well, perhaps if I can take it in, as I said, in order. There's a number of stages, which the industrial court took into account. So this isn't a binary one. Well, the Supreme Court said that one document effectively trumped everything else. What we say on this appeal is that being that the Supreme Court can only overturn a finding of fact by the industrial court on grounds of perversity, therefore we must find that there's either no evidence or evidence which meets the test manifestly wrong or plainly wrong or something along those lines. It must be a...
That's if you're right in characterising this as a finding in fact. I mean, is there a finding in fact by the industrial court that there was early termination of the contract by mutual agreement of the two parties?
No, the finding of fact of the industrial court was a break of 28 days employment between the 24th of November, when this occurred, when whatever happened between Mr Appadoo and the HR officer and SBM Bank took effect on the 24th. They find that there was a termination on the 24th and that there was a re-employment on the 24th of December. And so there was a break of more than 28 days. That's the finding of fact by the
Why is
industrial
that a finding of fact? That's a legal characterisation of a number of facts. And you've said that there was nobody who gave evidence. I had a conversation with Mr Appadoo. I told him although we said 30th, it's actually 24th, so that we can have a 28-day break. There was no, I mean, that would, and if he had denied that conversation had taken place, then there would be a dispute of fact as to whether that conversation took place. But I don't think that's what you're talking about as to a finding of fact.
The question of fact is, was Mr Appadoo employed after the 24th of November?
Well, no, because you couldn't have terminated unilaterally on the 24th, could you? No. There was a 6-month notice period in that contract, and it only expired on the 30th.
We couldn't have lawfully terminated. We could have terminated, but we couldn't have lawfully terminated.
No.
Could you even have effectively terminated it? Are you talking about simply a repudiation of the contract?
Yes, I mean, effectively, it could have been
Would that be effective in Mauritian law to bring the contract to an end?
Well, that's not the case that was put forward by at the industrial court, or indeed one that I'm putting forward now. But as a matter of fact,
so it's not enough just to say termination. You've got to say termination by agreement for it to be an effective termination.
Well, I do say, because that's the evidence that was before the industrial court.
That wasn't the positive case asserted in your defence to this claim, was it?
Just termination was what was put forward.
I don't even think termination. I think expiry or ceased were the words.
Certainly ceased, but I think termination also.
Okay. So in order for there to be a termination on the 24th, that would have had to be by agreement.
Yes, on the 23rd.
You say on the 23rd?
You say on the 23rd, yes.
So what evidence was there of Mr Appadoo agreeing?
So the evidence was, well, let's go through this in stages then. I'll skip my intro and I was going to deal with the points of law first, but in terms of the test, because effectively the significant question is whether or not the Supreme Court can overturn an issue of fact or question of this.
Pretty well-trodden area as far as this court is
concerned. Yes, And what you've seen is that the Supreme Court appears to have used a weight of evidence test.
I mean, you can understand where the interest of the board is.
I can, but perhaps just in summary then, just to say it appears on the law that there is no longer the dispute that I thought there would be between myself and Mr Duval, in that he also cites Smeg and Persad 2012 Privy Council case, which is in the electronic bundle at 993, as being the correct test, that an appeal against the industrial court can only succeed if the industrial court has erred in principle by asking itself the wrong question. That's not the case in this case, or made findings which were perverse or manifestly wrong. And you've seen in our written case that we elaborate on that in the well-known case, as you've mentioned, my Lord, Kersner and others. Now, perhaps I don't need to go through those, but effectively the question is this, that the appellate court, the Supreme Court, and indeed this court, need to have caution in reversing a judge's evaluation, particularly in a situation where this is a specialist jurisdiction, because the industrial court of Mauritius only hears, the judges there only hear employment cases, and so bring to bear expertise upon this. So the correct approach is that the Supreme Court of Mauritius is bound by the findings of the industrial court unless it can be shown that they were perverse, manifestly wrong, or irrational, in the sense that no reasonable court would have reached that, or there was no evidence to support it. So I'll move on quickly past the points that are raised by Mr Duval on Pleshakov, which in paragraph 32 of his case, that's not, in my submission, the threshold that applies to the industrial court. It's the Smeg and Persad ones as elaborated in Toloco, which is the Supreme Court case of Mauritius, specifically based on industrial court findings. And in relation, finally, on this point, just to EDU and the state, which is the one that the Supreme Court did cite and rely upon, I think it probably, just before I go on to look at the bits of evidence, it's probably useful just to see what it was that the Supreme Court looked at in EDU. And perhaps I can take you to electronic bundle page EB 785. You'll see there that this is page 8 of the EDU judgment. The Supreme Court first takes the words of Ben Max and Austin Motors about the trial judge having seen and heard the witnesses, then goes on halfway down the page to the Mauritian case of Moutalou and the Queen, and says that it's settled that the appellate court should not likely reverse the finding of the trial judge. Then looks at Lau Dasing and the State, 2008, and says, as can be seen in all the first 5 grounds, have to do with the appreciation of facts by the trial court, and appellate jurisdiction is ill-placed to intervene in a matter where the appeal based on facts which the trial court's appreciation remains sovereign unless the conclusion reached by the trial magistrate appears to be perverse. The underlining is ours. And then comes the words that were cited by the Supreme Court in this case and relied upon by Mr Duval, which is the words perverse is not used here in its usual pejorative sense, but is meant to convey the idea that the finding of the trial court is against the weight of the evidence adduced at the trial and is thus characterised by an abnormal or unacceptable tendency, which is contrary to what is expected by the circumstances. And it must be said that I've struggled with what the words abnormal or unacceptable tendency, which is contrary to what is expected in the circumstances, really means in relation to the classic perversity test as set out in Smeg and Persad for the industrial court. But we perhaps see what the Supreme Court was meaning in EDU if we go to the bottom of the next paragraph, where, perhaps I'll read the whole paragraph. It's not because counsel does not agree with the analysis of the trial magistrate, or because counsel is of the opinion that the magistrate should have taken another approach, that he can rush to the appellate court and ask the findings of facts to be upset. There is an objective element that has to be met. In the case of Mutalu Supra, the Supreme Court emphasised that there must be sufficient indications that the trial court failed to appreciate the facts properly. Additionally, the notion of the finding being perverse carries with it the idea that the conclusions of the trial court are shown to be unacceptable. It therefore follows that the grounds of appeal and the skeleton arguments must set out quite clearly and in concrete terms what amounts to the gross misapprehension of the facts, or, in other words, what are the elements which are said to be perverse. So
you agree, you say that's the test that the Supreme Court should have applied?
Well, that explains perhaps what is meant by the rather opaque words abnormal or unacceptable tendency. It looks like that's the more standard test that the courts read below has reached a gross misapprehension of the facts, which really is consistent with the it's plainly wrong test of perversity that we're...
This is an example of the dangers of taking one sentence out of a judgment and focusing on that. If you read these two pages together, it's pretty clear what the court is saying.
Indeed. And so what we say the Supreme Court did in then effectively taking one document, one piece of evidence, and saying that that one should have been given greater weight than the industrial court did, we say that's an error because that's not something that is...
Is that a fair characterisation of what they did? I'm looking at the paragraph that says that the evidence at trial didn't reveal any expiry of the contract on the 24th of November, and there was no evidence that the appellant was notified of any premature unilateral termination of his contract 6 days before expiry. Well, that is, if that's right, that's a proper application of the perversity test.
If there's no evidence
Yes.
of termination.
Yep. No evidence of...
And that's...
Of mutual agreement.
Mutual rather than unilateral.
That's what you have to establish.
See, what I'm concerned about in this context, on page 676, is what the Supreme Court says near the top of the page, lines 8 to 10, that it was not the case before the industrial court that there was an agreement between the appellant and the respondent. The contract of employment of the appellant would expire on...
Yes, we say that's wrong.
That's wrong.
That's wrong, because, and we can see that from what Mr Luchman said and what the industrial court looked at on page 393 in the exit checklist. Right. Well, let's go through the evidence now.
So are you saying there's a difference between the EDU test and the SMEG and PERSAD test, or are they the same test, or if they're different, which one is the one you say should apply?
Well, SMEG and PERSAD is the classic test, and it's the test as elucidated by this court.
And that's for an industrial court?
For an industrial court. And,
right.
well, perhaps if I could just take you, it's said in, the reason I've taken to EDU is that EDU uses those slightly, a tricky language, which really isn't quite clear what those first words mean, which is why I took you to the rest of the paragraph, which effectively suggests that it's much more in line with the PERSAD. But if you look at electronic bundle 993...
SMEG is perverse or manifestly wrong?
Yes.
Is that, and that's what you say
actually,
is the test?
So SMEG starts at page 993, and the relevant parts of the test is at page 1000 and page 1003. If we look at 1000 first, you can see there at the bottom of the page, paragraph 19, what the board said there is it's accepted on behalf of SMEG that the Court of Appeal, which is the Supreme Court of Mauritius in this case, applied the correct test. In other words, the appeal could only succeed if the industrial court erred in principle by asking itself the wrong question or making findings which were perverse or manifestly wrong. And then that's then effectively put into effect by the Privy Council on page 1003 at paragraph 27, where the board says, this appeal must be dismissed. The magistrate reached a conclusion on the facts which was plainly open to him. He heard the witnesses and made an assessment of their evidence. His decision was not perverse or manifestly ill-founded. So that's the classic test. and the words in EDU perhaps do not shed any real...
Oh, I see.
No,
So,
I mean, when-
so are you saying that if EDU is read as substituting for that against the weight of the evidence type test, a more relaxed test, and that's actually wrong when you look at EDU, it's actually applying the same test and you ignore that weight.
And indeed, I think Mr Duval
Yeah.
says that expressly in his written case, that if you look at the whole of EDU, and it's just taking those words out of context, which is perhaps what the Supreme Court said on those two occasions, it was about the weight of evidence.
Yeah, because a gross misapprehension of the facts is not very different, in a way, from what's said here.
No, exactly that, exactly that. So then, looking at the evidence, if I can take you first of all to page 207. This is the evidence heard by the Industrial Court from Mr Lutchman. You can see there at the top of the page that he has been an HR business partner for SBM Bank for 16 years, and he's well acquainted with the case of Mr Appadoo.
So where does he say that?
That's line 10.
What do you mean by that? Anyway, not to worry, it's okay.
So if he's been an employee of the bank for 39 years, then it looks as if this practice of having a 28-day gap has not been applied to him.
He being Mr Lutchman.
Mr Lutchman, yeah.
Well, we know it wasn't even applied to Mr Appadoo in relation to some of his...
I think that's right. I think it's because of the seniority. Employees who are not the most senior officers are employed on indeterminate contracts, not fixed-term contracts. So a normal contract of employment, if I can put it that way, which doesn't have an end date, which is terminable on notice. It appears that very senior people are employed on these fixed-term contracts, and Mr Lutchman's evidence is that the very senior people who are not protected by the worker provisions of Mauritian law have these 28-day breaks put between fixed-term contracts on occasion.
That didn't always happen even in Mr Appadoo's case.
No, that's correct. So Mr Lutchman is acquainted with the Mr Appadoo's case, and he confirms that the employment was terminated in 2017. That's after the gross misconduct that you may have seen. The situation was that Mr Appadoo did not disclose some financial reports to the board, and the Industrial Court found that the SBM Bank was entirely justified in terminating his employment for gross misconduct in 2017. But of course, the question for the Industrial Court and on the appeal is what happened in 2012. And he was shown at page 212, was asked about what happened on the 24th of November. You can see that at the top of the page.
He says that was his last day,
Yes,
but the exit document you showed us says the 23rd was his last day.
that's right.
So which is it?
Well, he says in that evidence, as you see, that what happened on the 24th of November, that in fact was his last day. His contract was terminated. His last working day was the 23rd, and the contract was terminated on the 24th. So he was paid for the 24th of November, and he was only taken off the payroll, according to the checklist, as of the 24th of November. So
Do we have evidence of pay slips or bank statements?
pay slips, yes.
Yes, that show a gap.
Yes and no. It's not my submission that a pay slip is determinative of whether somebody's in employment or not, because it could be that somebody actually, in fact, continues in employment, but is not paid for that period and actually has a claim for unpaid wages during that period. So I don't think it was relied upon below, and I don't rely on it here, as the fact that he wasn't paid during that period being itself determinative.
But you say his last working day was the 23rd of November.
Yes, and indeed, I can't even say that the Industrial Court relied upon it as a significant factor that he wasn't paid during that period because it's not mentioned in the industrial court judgment. So I think it would be unfair for me to jump on that particular bandwagon, even though there are documents in the bundle which, including his pay slips. So we have the, yes, we have the last day was the 24th of November, so that's the last day of employment. And 24th of November, the employment, you say, Mr Appadoo, was terminated. And Mr Lutchman says yes. So then to support your contention, I'm showing you, please identify an exit procedure checklist signed by an HR officer of the Human Resources Division of the bank. Please identify that document. And then he says that's an exit procedure checklist used by the bank, and so forth. And at the bottom of that page, he's asked about the last working day to Mr Appadoo. The last working day was 23rd of November. And then...
he's confirming the contents of the document. As per that checklist, when was the last working date?
Yes. So,
and he ceased to be in employment of the bank as from document D1, as from when. So he's reading the document which we can read.
Mr Lutchman, first of all, gives evidence that Mr Appadoo's employment was terminated on the 24th of November. He then is shown the exit document. As you say, we can all look at that. And what he says at page 200 and... One moment.
The document D1 is page 393.
Page 393, yes. Then page 214.
So Mr Suku was
Examining Mr Lutchman.
So he says you can confirm that the 23rd of May 2012 was when the...
That's 2017, is that right?
No, page 213, just at line 11, from document 1 you confirm that on
yes.
the 23rd of May 2012 the following items were collected.
That's 23rd of November. May must have been Mr Suku misspeaking. So he says...
Wasn't there also that gap, or was that at an earlier stage? There was a several-month gap between contracts which nobody argued was actually a cessation of employment.
That's right. That was earlier. Not relevant to 2012. So we have Mr... yes, we take 213. We have Mr Lutchman being asked about this document. It may be that we can effectively look between 393 and what we have here, because he's asked, first of all, to confirm that the following items were collected from Mr Appadoo. And if you look at 393, that's because what the HR officer does is ticks a number of things. Ticks on 393, issuing a letter to private banking, unflagging Mr Appadoo from the staff list. That's to happen on the 26th of November and has a tick. Issuing a mail to OPC to remove waiver on fees and charges from the system. That's done on the 26th of November through the same private banking. And then halfway down the page, collection of SBM properties. SBM tower access card, park card, laptop, mobile phone, keys, vehicles, live books. And that's ticked as happening on the 23rd of November by PM.
Right, but all Mr Lutchman's evidence is, yes, looking at this document, I see that that has been ticked.
Yes.
That's what his evidence is.
And crucially...
Before moving away from that, what does it mean by exit interview, which is not applicable? And what does it mean by sign-off to exit questionnaire?
So when...
Do we have the exit questionnaire?
No, so there's no exit questionnaire and there's no exit interview. Why is that? That's because it was just a 28-day gap. Mr Appadoo was not exiting the business permanently.
It was basically just an avoidance scheme to prevent him from benefiting from statutory employment protection. I mean, there's no real intention to get rid of him at all.
I mean, plainly, this standard practice of the bank, maybe it's not just that, my lord, but plainly, for very senior employees, 28 days break is placed deliberately in there because it's permitted under Mauritian law for very senior people to have a break which reduces severance allowance. And that was done, and what Mr Lutchman said is that's a standard practice for very senior people.
There's nothing wrong with the practice. If you actually enter into an agreement, you actually say to somebody, well, by the way, you're giving up a right, we want you to give up the right, we're going to give you a new contract, you've got to give up the right. And nothing like that occurred in this case.
Well, the industrial court, I say, said it did, and the reason for that is...
Where did they say there was a conversation of that nature?
Well,
Should we finish Mr Lutchman? Because
let me effectively show, because...
at the moment, all he's done is look at a document. He hasn't said, from my own knowledge...
Or speaking to Mr.
Speaking to Mr Sunasi, I know that this agreement...
Yeah, so if we go...
Where does he
yes, we
agree?
go back to 200, we're on 213,
Yeah.
and my lady rightly says he's talking about the document at this stage, and then at 214, what he does is he gives evidence about the documents that were then internally circulated within SBM.
But they were not sent by him or copied to him. They were all dealt with by Mr Sunasi and Devika Sukna.
No, that's not right. One of them was sent and copied to Mr Appadoo. He denied seeing them, but one was sent to him. I'll show you that in a moment.
Okay.
So what Mr Lutchman gives evidence about is that the things that were ticked by the HR officer as having been done were actually done, and that there were documents to show that Mr Appadoo was disconnected from the IT system. And the emails, that's at page 214. And you see there that the message was that the below named will cease being an employee of SBM Group. And if we go to that page, what's that? the email that was copied to Mr Appadoo. That's, yes, 394 in the electronic bundle. So this is, as you see at the top in manuscript, document D2 that was being given in evidence by Mr Lutchman at the time. And in the normal way of emails, one reads from the bottom up. So we can see that the bottom of the email is an email on the 23rd of November at 6:03 p.m. From Mr Sunasay, the HR officer, to the IT service desk, IT platforms, and to the FM help desk, copied to some other people. You are hereby informed that the below named will cease to be an employee of the SBM Group as follows, and that's Mr Appadoo, departure date 24th of November. That's then copied by Mr Sunasay to Mr Appadoo at 6:03 p.m. on the same day, with just FYI, so for your information. And the significance of that is, this is just an FYI, so this is something that Mr Appadoo knows about already. This is something Mr Appadoo has...
Well, it's not saying, do you agree, is it?
No, but, my lady, I'm saying that's why it just says FYI. It's something that Mr Appadoo already knows about.
Why?
Because it's not sent to him as any surprise, or this isn't the news to him. Why? Because on the 23rd of November, there was agreement to his last working day, and that was ticked by the HR officer. So Mr Sunasay is sending this just as a for your information email to Mr Appadoo, because the obvious inference of that is this is something Mr Appadoo already knows about. And of course, what we don't have is Mr Appadoo saying anything. There's no complaint or demur at all for Mr Appadoo to anything that goes on here. Indeed, as I'll come to in a moment, we know that Mr Appadoo agreed that Mr Lutchman was right, that he handed back his work laptop and his work mobile phone on the 23rd of November.
Was the point you've just made put to Mr Appadoo about this FYI email? Was that put to him? Well, that shows you had agreed the previous day.
I'll come to that in a moment. He denies seeing any of the documents, or he didn't recall a number of things being collected from him, and he said he wasn't aware.
There's no finding by the industrial court, is there, about this email?
The industrial court records this as one of the documents which suggests that the employment was terminated. You may recall that they put a list of the documents they say are supportive and a list of the documents they say are against, and then compare the two. And so this is part of the evidence before the industrial court.
But I mean, it's quite significant, this FYI bit. I mean, some of the documents which are in the list you refer to are clearly not documents that were shared with Mr Appadoo.
Exactly.
But the point you've just made is simply not made by the industrial court.
The industrial court don't say,
no,
this is the answer to the case, no. But
Well, they don't even mention it. They don't mention that this email was drawn to his attention.
no. But they do say that Mr Appadoo denied all of it, even though, in complete contradiction, he then accepted that he had given back his work equipment.
Well, he didn't accept giving back the other stuff.
He said he
He
didn't.
just said he gave back the laptop and the
Well, the
mobile
laptop
phone.
was collected, but
Yeah.
he said he still worked over the period on the negotiations
And
of
the industrial court,
contract.
of course, are entirely entitled to say, well, you cannot work without your laptop.
Well, he wasn't. That wasn't put to him, though, was it? It was. He was asked, "Was your laptop collected?" And he said yes. And there wasn't any follow-up. Well, then, how is it you say that you work? I mean,
But
the laptop could be collected for all sorts of reasons.
the laptop could be collected for all sorts of reasons, but the evidence for the industrial court was the laptop was collected as part of his exit process. There was an exit process on the 23rd of November, and as a result of his exit, he handed back his work equipment. He said he couldn't recall handing back his ID card and so forth, but he said he did recall handing back his laptop and his mobile phone. And the industrial court was absolutely entitled to say, well, it's almost impossible for him not to have agreed to the ending of his employment for 28 days, and in circumstances where he agrees that he's given back his key work equipment.
well, I'm
Mr.
not sure
Burns, I
that
think
follows
sorry.
logically. I mean, if the employer comes along and says, give us back our laptop, because the laptop belongs to the bank,
Yes.
he's not in a position to refuse. That doesn't follow from that he has agreed to the termination of his contract of employment.
Not alone, but
I may have, this email here, it is fair to say
Yes,
that
I
the
was about to
industrial
say.
court lists the deactivation of ID emails, document D2, especially the email dated 23rd November, which I would take, I mean, there are two on the 23rd, but
It must be
I think
the-
it's fair to infer that the court was referring to the one you've particularly shown us.
it was plainly taken into account by the industrial court.
I would agree.
And what the Supreme Court have to then say is, was there no evidence from Mr Lutchman, from the exit checklist, from this email, which suggests that there was an agreed termination?
I mean, we come back to the problem that there's no finding of an agreement. I mean, this I can see is evidence of communication of the termination. But it's the question of the agreement which is so critical.
Going back to Mr Lutchman, to finish off what he said at the page 215, I think we got to, we have the offer of the new employment taking effect from the 24th of November, ending on the 31st of December 2017. He's then asked, well, it's put to him, there was a break of how many days between a prior employment of the 24th of November and the new employment taken on the 24th of November 2012. That must be December, and his answer, Mr Lutchman's answer, is it's more than 28 days. He's then referred to document D6, which is the report of the bank to the shareholders at the AGM, and he's asked to look at what is reported to the shareholders, which at the industrial court was effectively put forward by Mr Appadoo as the key evidence, suggesting that he was he hadn't agreed to a termination because he was reappointed a couple of weeks later as a director of the bank. And then
there was a debate about whether he was an executive director or a non-executive director.
Yes.
I mean, it's not strictly accurate, that, or is it? I mean, he was not. The general meeting was asked to note that he was reappointed. So that was done by the board, was it? The reappointment.
Yes, he wasn't elected by the shareholders.
No.
The shareholders
Article
noted.
13.1 of the Constitution provides, it appears, for the appointment of ex officio members.
And in my submission, what the SBM Bank did was consistent with the fact that he was going to be, and there was always an intention, he was going to, after the end of the 28 days, be re-employed, because at that stage he was a valuable senior employee of the bank, but the bank intended to carry on being a senior employee of the bank. The bank were just inserting the standard 28-day break Mr Lutchman gave evidence about, and the intention was for him to carry on being a ex officio director.
The thing about this is that, I mean, it was acknowledged by the industrial court as being something in favour of Mr Appadoo's case, but it was by others. And I think is this right, that before the industrial court, Mr Appadoo's case was in part that the internal bank documents had been created later and backdated to make it appear that his employment had been terminated.
Yes.
Am I right?
Mr Appadoo's case, roundly rejected by the industrial court, was this was all bad faith and not genuine on the part of...
They were not genuine. The documents you've been showing us were not created on the days they
Well, except when Mr Duval was challenged by the industrial court on, do you say that the exit checklist is not an authentic document? I'll show you the exchange. There was some toing and froing, and he, I think, fairly accepted that it was not challenged by Mr Appadoo that the exit checklist was an authentic document.
I see.
And in terms of the letter to the Bank of Mauritius, once again, it wasn't challenged that that was an authentic document. I think what Mr Appadoo said is that effectively SBM Bank were lying to its regulator, that Mr Appadoo was having a 28-day termination period. And the industrial court said, well, it's a serious thing for a bank to mislead its regulator, and took that into account as part of the balance of finding that he was terminated on the 24th of November. So going back to page 216, we have the answer at line 10 from Mr Lutchman, who says, I can speak strictly from the HR perspective, so I only know about the employment of Mr Appadoo, so I know that as from the 24th of November, he was no more in the employment of the bank. Question, he was no more in the employment. Yes, because I was not involved in this process at the board level, I would not know about his directorship or his appointment there, but only from his employment, from HR perspective, he was no more in the employment of the bank as from the 24th of November 2012. So what Mr Lutchman was saying is that he had personal knowledge of Mr Appadoo being an employee, but he didn't have personal knowledge of Mr Appadoo being a director.
But why do you say personal? Where does he say has personal knowledge? I mean, I thought he was... You think in that answer he's referring to something more than the ticks on the checklist?
Well, he says what he says, which is, I only know about the employment of Mr Appadoo. The employment of Mr Appadoo.
Well, but that's employment as opposed to board
directorship.
So
Mr Lutchman...
But he's not saying it's personal knowledge. He's just saying HR deals with employment, the board deals with directors.
Certainly it's open to the industrial court to find that what Mr Lutchman says about what he knows is what he knows personally.
If they make that finding, yes. I don't think they refer to Mr Lutchman's evidence at all, do they?
They refer to him as being the representative of the bank. So
That's
yes,
all they say.
they say that they say representative of the bank, and they accept his evidence as not being lying to the.
So what's your case on the directorship then? He was a director, he was an executive director up to the 24th of November. He was then a non-executive director from the 24th November to the 24th of December, and then he became an executive director. Is that what you're saying?
I think the crucial thing is this. The AGM was on the 13th of December.
Yes.
On the 13th of December, the shareholders were being asked to note that the SBM Bank were intending to reappoint him as a director.
I think
No, they had
they
reappointed.
had reappointed him.
And on the 12th of December, so the day before, the bank secured Mr Appadoo's agreement to re-employment as from the 24th. So effectively, the bank had in their hand Mr Appadoo's signature on the new employment fixed-term contract on the 12th. That meant that they could go to the board, and so the shareholders, in good conscience on the 13th and say, Mr Appadoo, we've asked for you to note that his reappointment as an executive, because they knew they had him continuing. He wasn't at that stage in limbo.
I mean, I think the trouble about all this is that we haven't got Article 13.1 of the Constitution, so we don't know what the requirements were. We don't know whether it was required that there should be a resolution of the board that he continue in office or be appointed. We've not seen any resolutions of the board.
And nor did the Industrial Court.
Where it's, I'm sorry?
Nor did the Industrial Court. And that,
Oh, right.
the Industrial Court, I don't think, had that in front of it.
So you're saying that when the AGM was asked to note that he had been reappointed, what they were being told was he's going to be reappointed at the end of December, not that he had been reappointed on the 12th of December.
I think the reality is that the directorship, what Mr Lutchman says is, although he says he doesn't know personally, or he doesn't know about it, Mr Lutchman's evidence, I think, read fairly, is that the directorship continued. It was only the employment which had a gap. So there was no break in him being a director, because that's different. You don't. It's different, Mr Lutchman says, being a director from being an employee. So there was a break in employment. But as far as the shareholders are concerned, they weren't told about any break in his directorship.
I think the counter-argument is, isn't it, that he could only continue as a director if he were an executive. Which
is, I say, why the bank had the 12th of December contract in their hands before.
I don't know, but I think without seeing the articles and without seeing the board minutes, it's very difficult.
That's my assumption rather than matters of before the Industrial Court.
But you accept, I think, that he was a director throughout the whole period.
I can't be sure one way or another, because we haven't got.
I mean, there are no findings about this.
Yes, that's most we've got is at the bottom of page 215, because Mr Lutchman is asked at the bottom of that page, Mr Lutchman, at this juncture, please be mindful of my question. Firstly, at the 20th of November, does the bank dispute that Mr Appadoo was a director on the board? And he says no. So that suggests Mr Lutchman saying that he continues to be a director. He just doesn't continue to be an employee.
Well, the 20th
That's
of
the
November
20th.
was even before you say he was.
Yeah.
And then he's asked about the 24th and he says he can't say.
Yes.
Yeah.
I've just been looking again at the transcript of Mr Appadoo's evidence. But so far as I can see, the FYI email wasn't put to him. The only one on that page that was the one that, as far as I can see, I may be missing it, but as far as I can see, the only one that was put to him was the one at the top of the page to Devika Sukna, asking her to unflag Mr Appadoo from the staff list.
Let's just look.
That's on page 196.
Yes, so this section starts at the top of page 194. If I take you to the whole of this so that you can see the context for this, of what's gone through. First of all, Mr Appadoo is taken on page 192 to the exit procedure checklist. And it said, Mr Appadoo, I'd like to show you a document which is called the exit procedure checklist, whereby it mentions your date of departure as being 24th of November 2012, where collection of SBM properties and various things. I'd like to show you the document. Mr Duval objects and says, what's the relevance of this? And he says, I'm sorry, I expected, in the light of the question of my client being shown an exit procedure checklist, I imagine the only relevance of such a question would arise if my client had actually signed this exit procedure checklist. So if it's not even signed by my client, why are we talking about this checklist? Mr Person says, well, the issue with this, if and when the contract was terminated in November 2012, the case of the bank is that the contract had been terminated since 24th November. We want to produce evidence which shows that, in fact, that was indeed the case and the reason why those documents are being confronted. Because ultimately, the HR officer will produce those documents. Mr Duval says, again, a document which is not signed by my client has kept this evidence. It doesn't mean that it has to be signed by him for the document to be produced in evidence. The officer of the bank will produce the evidence, which shows, will be up to your honour to decide whether these documents tend to prove that the contract was indeed terminated or not. And Mr Duval says his objections of relevance. Top of the next page, the court, the industrial court says, are you challenging? And then Mr Duval comes in and says, it's not about it being signed or not. My objections of relevance. And then the industrial court says, but Mr Person has explained the relevance of the document. Are you challenging the authenticity of the document, Mr Duval? And he says, no, I'm challenging the relevance, because my client just put it to him that there was an exit procedure list which he has not signed. So what I mean, the bank has an exit procedure. I think we can take judicial notice of that, that a bank like SBM would have a procedure for exit. I will expect it, my friend put it to the plaintiff that he did anything which confirmed his instruction that he indeed left and did not work, but that there is a procedure, Your Honour, I'm willing to accept it. And that's what at least I would expect from a bank like SBM. I don't see the relevance to our case. And the court says, Mr Person has explained the relevance of the document as the date on which what the defendant is saying, the employment of the plaintiff was terminated in November, whether it was on the 30th of November, as averred by the plaintiff, at paragraph 2.3. And Mr Duval says, I've made my point, my lady. And the court goes on, or whether it was terminated as averred by the defendant on the 24th of November, because Mr Person is canvassing the issue of the period, continuous period. Mr Duval says, yes, I think we agree that the case of the plaintiff is that there was no break in employment. The court says, yes, Mr Person is trying to establish the opposite. And he says, yes, I'm saying that he's not doing that by showing a procedure. What's happening, there's only a procedure, there's nothing which confirms. And the court says, okay, well, the court has not seen the document that was shown to the plaintiff. Is it merely the procedure, or is it the checklist that specifically relates to the plaintiff and what steps were taken in relation to the plaintiff? Mr Person says, well, let me put it this way. What is correct is the document which is shown to the plaintiff is not the document which has signed. Ultimately, the matter of credibility, when the witness will come to say that, no, he did hand over this and that, this and this item, that's ultimately a matter for your honour to decide. But I have a document which tends to show that the items were collected, which goes a long way to show that the employment would have been terminated. If it had been signed, so be it. It's not been signed, I agree. Ultimately, it will be for your honour to decide whether your honour accepts the evidence of the HR that indeed these items were remitted as a result of the employment being terminated on the 24th.
But no such evidence actually was led at the end of the day. The witness who was led simply read the document.
Well, perhaps I can go on just for the moment to finish this point. If you see at the bottom of the page, Mr Duval says the document generated by the defendant purporting to record a list of equipment to be collected from that's my client, from a cursory look. It's what I understand. It's part of the procedure of the bank, have a collection procedure, and the document, we don't know who filed it, but it relates to the equipment which was in possession of apparently the defendant at the time, of the plaintiff, I'm sorry, yes, right. Again, if you're not going to challenge the content, Mr Duval says, no, I'm not, of the document, of the authenticity, then the court will have to hear arguments. So what we have here is Mr Duval not challenging that the checklist is authentic.
Well, what does that mean, authentic?
Well,
I mean, what is it?
It's a genuine document.
But there's nothing here about whether there's anything in the document or anything in his evidence that his laptop was collected that shows that he consented to his contract terminating on the 24th of November.
Lady, I think, yes, it does, because what Mr Duval goes on, the court asked, are you challenging the content? And he says, no, I'm not. So the content of the checklist, which includes the HR officer ticking to say that there's been agreement as the last working day, the content of that checklist...
The attention hasn't been directed to that one. I mean, that would be a big point to concede at the trial, and it's not been squarely raised.
Well, Mr Duval obviously is experienced counsel who's looked at this document, who knows the contents of it. His client is, as we see in a moment, going to give evidence about
the authenticity. I mean, it's not a forged document. Somebody has filled the thing in, but the fact that somebody's filled in, no doubt, honestly, exit date 23rd November doesn't mean to say that Mr Appadoo agreed to the termination of his contract of employment on the 23rd of November.
But, my lord, I'd say it's strong evidence that he did. We don't have the agreement, we don't have as Mr Person says, we don't have
any evidence at all that he did.
Well, nobody asked. I mean, was there somewhere where it said to Mr Appadoo, you met with Mr Sunasi and you went through this and you agreed with him that your contract was going to...
Well, let's go, because let's go on, because we've just had this long debate between the court and Mr Duval about the objection.
Before we do that, again, just the proviso that I can't resist asking, why wasn't Mr Suzuman called as a witness?
Mr Suzuman's I don't know. I don't know, but I assume Mr Lutchman is the senior HR business partner. Mr Sussman is the more junior person. Yep. And it's not uncommon in a employment case to call somebody who's more senior rather than somebody who's at the bottom of the food chain.
Well, it depends what the issue is. If the critical question is, was there an agreement to terminate, you would have thought that the person who reached the agreement might be called.
I accept. So then we have then... The court then effectively says, otherwise, if it's only in relation to relevance, the court is at the considered view that the document is relevant in view of the averments of the defendant that the plaintiff's employment, according to the defendant, was terminated on the 24th of November 2012. So Mr Person continues, showing you the document, and then do you agree that you're...
So which page is this?
195.
Thank you.
And we're at just above line 20. And so he says he doesn't recall the park card being collected. He doesn't recall the tower access card being collected. He agrees that his laptop and mobile phone was collected. He doesn't recall keys, vehicles, library books being collected. Then the top of the next page, 196, he shows him the next document, which is the internal communication addressed to the tower users, service unit, area leaders, personal bankers. You can read that there. Dear colleagues, please be advised, Mr Appadoo and Miss Nuku of CCP employees. The witness is shown the document, and then the email dated the 26th of November, addressed by Ms Susan C. to Ms Devika Sukna. And she works in private banking, and the subject is the deactivation of ID, which reads as follows. That's the document. What page is that? That's the one that's at 394 of the electronic.
That's the one above the FYI one.
So it's the same page.
But it's above the FYI one. It's not the one that was FYI'd to Mr Appadoo,
That's
is it?
right. So we're looking at the same page.
No, I know.
And we're looking, the attention is drawn to the top of that email, as my lady says.
Yes.
Uh,
So my lord asked you, where's the FYI one being put to Mr Appadoo? But it wasn't, was it?
I think that's the, yes, what's not, that's the page being put, but
Yeah.
not the
Well, a different
Not the
email
extract.
on that page, which
and what
wasn't copied to.
What wasn't put specifically, I accept, is well, what did you do in reaction to the FYI? That wasn't put.
Well, it wasn't put.
That
Doesn't that show that you must have agreed to the termination of your contract?
No, that wasn't put.
And we've now gone on to the 26th of November, so I'm assuming it wasn't put to Mr Appadoo. Well, Mr Sunasi sat down with you on the 23rd and he went through this checklist and he agreed with you that your contract was going to terminate. Is that right?
The conversation
Was not put.
not put.
Wasn't even put to him that the person who had the conversation was Mr Sunasi. Mr Sunasi's name doesn't...
Just referred to as HR officer in the exchange before, not referred to by name, no. We then, going back to Mr Lutchman, the next evidence that the industrial...
And sorry, is that's the height of the case that was put to him? Those pages, 195 to 197. I think on page 204 it was put to him that he wasn't employed in the interim. And he said, yes, he was. But that's it.
I'm shown on page 191 that the name was put during the cross-examination to Mr Appadoo. I apologise. That's Mr Person at the top of page 191.
Oh, and Manoj is rather
Mr Sunasi. So it was put to him that Mr Sunasi sent an email to somebody else, but it wasn't put to him that Mr Sunasi sat down with him and had a conversation in which they agreed to terminate his contract early. Yes?
That must
Is
be.
that right? Okay.
So the industrial court had that evidence from Mr Appadoo, and the height of the evidence is the acceptance that the checklist was correct in... He accepted that the checklist was correct in the fact that on the 23rd of November he did return his work equipment, namely the laptop and the mobile phone, and that he didn't recall the other parts of the work equipment being. And on behalf of Mr Appadoo, there's the acceptance that the checklist itself is not a forgery, it's a genuine document, and there's acceptance of its contents. And it's in my submissions, the industrial court can take into account that Mr Appadoo accepts that the exit procedure took place as indicated in the exit procedure checklist.
Sorry,
because of two things. Yep. First, because his counsel accepts that the contents of the checklist. Secondly, because when he was asked about, three things. Secondly, when he's asked about one of the things that he's personally involved in, he accepts that it's correct when it's ticked to say that laptop and mobile phone are collected by his employer on the 23rd. And third, because the industrial court has shown that the other documents that the checklist shows were completed, the internal documents telling his work colleagues that his employment had been terminated, were also sent, and he was shown those emails in the way that we've just looked at. So the checklist is a genuine document. It's likely that the checklist, when it ticks things, it's correct that those things did happen. And one of the things that is ticked is agreement on last working day.
Which you infer is not only that he agreed that that was going to be his last working day, but that he agreed to the termination of his employment.
He could only have...
You can be sacked unfairly and told, right, don't come in tomorrow.
But then there's no agreement
agree that
on the last working day.
Yeah,
in this case,
the last working day.
What the industrial court had in front of it was evidence that there was agreement on the last working day, and that's only consistent with agreed termination. If you're dismissed, you're told what your last working day is.
Where was this put to him that he agreed that 23rd November would be or was his last working day?
No, but when his counsel was asked about it by the court, counsel agreed the contents of the document were not disputed. So in those circumstances, I don't think it's necessary for Mr Appadoo to be asked about each individual tick, whether he agrees that that content is correct.
The core issue in the case is whether he mutually agreed that this was going to be the termination of his contract.
Yes.
And so the only major issue wasn't put to him.
Certainly, the existence of a conversation, of an agreement, oral conversation, an oral agreement between him and the HR officer on the 23rd was not expressly put to him, no.
Well, because nobody at the time seems to have thought that it mattered whether it was with his agreement or not. It seems to have been conducted on the basis that it was for the company to decide when his last working day was, and that was what the debate was, but the significance of him actually agreeing to the termination of his employment for 28 days doesn't seem to have been explored in the evidence. Would that be fair?
The reasons for the 28-day were explored by with Mr Lutchman at page 240. If you look at...
No, my lady's putting to you that it doesn't look as though the bank thought it mattered whether Mr Appadoo agreed to the break or not. The company appears to proceed on the basis that they were entitled to require the break, but that it didn't have to be agreed by Mr Appadoo.
And that explains why none of this was put to him. And
why in the defence to the claim they didn't rely on agreement to terminate.
Certainly, as my ladies say, the way in which it's put by the bank is just termination and not termination by agreement. But you've heard me say it a number of times. When we look at what actually process did happen on the 23rd of November, we've got the tick not against dismissal or expiry, but against agreement on last working day. So that's what I say the industrial court had in front of it and was entitled to take into account. And what Mr Lutchman said, page, as I said, just page 240, he's asked at line 20, line 21, in fact, it was important to have on record that there was a break of 28 days to avoid continuity of employment. His answer was, Your Honour, this is normal practice between two contracts. We have breaks of more than 28 days. And the question is, no, it's not a practice. I'm sorry. I put to you that it's not a practice. you only ensure that there are 28 days if you don't want to have continuity of employment. And his answer was, Your Honour, I'm there in HR for 16 years. I can tell you that at the material time, it was a general practice for all people working on contract of determined duration. And the question at the top of the next page, 241, and why was that practiced? And the answer was, it's a management decision that we need to have a break between two contracts. And so that's perhaps consistent with what Milady was saying, is that the bank effectively saw itself as being entitled to have 28 days between contracts. Perhaps Mr Appadoo was given Hobson's choice about it. But
well, if he's given Hobson's choice, then they dismissed him on their case. They dismissed him on the 24th of November without his agreement. And if he'd gone to the tribunal then and asked for severance pay based on his long service, he would have got it, wouldn't he? Because there's no reason to dismiss him other than to make sure if they decide to dismiss him at some time in the future, they can, if they choose, say that he's only been employed for a few years.
The scenario in my submission is this, that if Mr Appadoo had not been willing to have the 28-day break at that point on the 23rd of November, then all the bank would have needed to do is wait 1 week until the 30th of November.
Yes.
His contract expires on that date, and then start the 28-day period and then only re-employ him.
Well, that then goes back to the question of what it means by a 28-day break in employment in the statute, that if he actually keeps coming into work and they pay him, then there would be a question of statutory interpretation of what it means in the legislation, but we're not dealing with that.
No, but for whatever reason,
case, yeah.
The evidence before the industrial court is that the bank didn't, and Mr Appadoo and the bank didn't wait until the 30th, the end of the short extension. There was a short extension of 6 weeks. They didn't wait until the end of that short extension and then do the exit checklist procedure on the 30th. They did it the week before on the 23rd and 24th. And
they made a mistake.
well, in my submission, Mr Appadoo went along with that. He agreed to it, hence the tick, and therefore the bank didn't need to wait another week. Just want to check whether or not there's any of the... Ms Masood was going to go through this, but I think probably I've covered everything that she was going to take you through in answer to your questions.
And Mr Luchman doesn't at any stage say, I know, because I chatted to him afterwards, that Mr Sunasi sat down with Mr Appadoo and they agreed to the early termination on the 24th of November.
Mr Luchman just says, I know, and
Well,
the industrial court...
He says,
Yeah.
I know as HR officer what happens with employment.
What happened with Mr Appadoo? He says specifically he knows
Remind me
what
which
happened.
page that is.
That's,
I thought the first thing an HR officer would do is ask the person who is supposed to have ticked the form. Be round to his office straight away. Tell me more about it.
well,
Can I have a witness statement? Sort of thing.
what the board, in my submission, mustn't do
Yep.
is effectively do what I say the Supreme Court did, which is effectively look at all this evidence and think, well, that's a bit thin in this respect. We don't think there's enough here to show that Mr Appadoo did agree to his last working day on the 23rd, and by putting the parts of the jigsaw together that the industrial court did, we wouldn't have come to the same conclusion. And there is a severe risk the board is taking the same sort of approach, which is effectively looking at this evidence forensically for itself and weighing what's in the balance. Now,
I think the board has identified for the first time in this case the importance of agreement to the termination of the contract, and we've looked for evidence of agreement, and at the moment we haven't seen anything other than the hearsay evidence as to the contents of the exit form.
The board, my submission must assume that the industrial court, with its expertise, looked at what happened on the 23rd. The only thing that the industrial court had to do is look at what happened on the 23rd of November and decide whether Mr Appadoo was correct, that nothing had happened on that day, and that his employment had continued throughout, because that was his evidence. I just continued working. There was no exit. This is all a bad faith job that the bank has put together after the effect. Or whether Ms Lutchman was correct, that there had been an exit procedure on this day and that there was a 28-day termination that he knew about. And so the industrial court had two witnesses in front of it to assess. Mr Appadoo saying that none of this happened, there was no exit procedure. Mr Lutchman, who said that there was an exit procedure on that day. And the industrial court had to assess that evidence, including the credibility of the witnesses. And Mr Person, as you saw in his submission, said, well, this is a matter of credibility. The industrial court, have to look at the exit procedure checklist and decide whether or not this is a matter of credibility. Because, as Mr Person said, we don't have a signature from Mr Appadoo agreeing to the termination on the 23rd of November. And so this is obviously a case in which the submission was made. You have to draw an inference from all of the evidence in front of you as to what happened on the 23rd. Was it, as Mr Appadoo said, nothing happened on that day? Or was it, as Mr Lutchman said, there was an exit procedure that I know about on that day? And therefore, in front of the industrial court, it was rather binary. And
I just fully understand. Your case depends upon mutual agreement. That was a case that wasn't pleaded. It was a case that wasn't put in evidence in cross-examination to Mr Appadoo, and Mr Appadoo was given no opportunity to either agree or disagree with it. All three things.
our case was that there was a termination on the 23rd, which could only have been an termination by agreement.
Mutual agreement pleaded?
Not pleaded in those terms. Termination was agreed. But
and you've agreed already that it wasn't put to him?
Yes.
And that you agreed already, therefore, that he didn't have an opportunity to either agree or disagree with it?
I don't think that would be fair as what happened before the Industrial Court, because Mr Appadoo is being asked about a checklist which shows things happening on the 23rd of November, and therefore he does have an opportunity to give his account to the Industrial Court about what he says did or didn't happen on the 23rd of November. And of course he can absolutely say either something happened on the 23rd or nothing happened. His evidence is he didn't recall some of it. He accepted that some of it did happen, and he wasn't aware of the documents that were recorded as being sent.
But is it your case that there was a meeting with him at which this was discussed, or is that not your case?
Yes, because the tick against agreement for the last working day can only have been I suppose it could have been an agreement in a document we don't have and that wasn't before the Industrial Court.
Or maybe it's just that someone put that tick there once they'd sent that email to him on the 23rd, FYI. We just don't know.
That wouldn't be agreement. That's
But just help us about your pleading, because Mr Appadoo specifically pleads that he was continuously employed. And on page 110, it starts on page 109, you deny those paragraphs of his pleading. And at B, you just say he ceased to be in employment. I mean, if there really wasn't a mutual agreement and Mr Sanasi sat down with him, why not plead it?
I don't know the answer to why not plead it?
Well, cease to be in employment sounds like you thought his contract expired, that it came to an end. Doesn't sound like any sort of agreement.
Well, what we see just before that
Yeah.
is that first, by way of a letter, the contract was extended up until the 30th of
Yeah.
November. It then ceased on the 24th. Therefore, it ceased because something happened.
Well, it says at 4, upon expiry of that contract, oh, that's May 12th,
Yeah.
remained in employment until 24th November 2012.
We're going round in circles here. I mean, this point about an agreement, as my lady says, was never pleaded, doesn't seem to have been put. I've not seen any reference to any submissions being made to the industrial court about an agreement along the lines that you suggested, that the exit procedure document proves it. There's no finding by the industrial court about an agreement. I mean, it just wasn't there, was it?
What was pleaded was that the contract, the fixed-term contract, went up to the 30th of November, and that the contract, then the plaintiff then ceased to be in employment as from the 24th of November. And it's not pleaded that he was dismissed. It's not pleaded, well, it's obviously not pleaded that the contract expired on that day, because it's just been pleaded that the contract expired 6 days later. Therefore, in my submission, the only way in which the bank could have been putting this is that this ceased early by virtue of agreement between the parties. But it's not
consistent with BE that he had been dismissed.
Well, there's no pleading that he was dismissed as.
But I mean,
before.
you can't. It just doesn't appear.
I mean, effectively, it's pleaded in a way which can be read in
Not
more than one way.
at all. You're doing a very good job of trying to extract from the word.
I'm sorry, could I also ask you again just to give me some assistance in relation to the document of 393 and the agreement on last working day? Does agreement refer to an agreement within the HR department as to last working day, or does it refer to an agreement performed on? Agreement on last working day performed on.
So
And performed by, why is that not applicable? Who performs an agreement on the last working day? Does it say agreement with the employee as to last working day? Or what does it mean?
we have a number of tasks, all of which are set out not in any legalistic way, but in a very ordinary business-like way. There's a list of things, and I suspect that nobody looking at this list would have thought that it would be forensically analysed to this complexity. But if we just think about what this looks in an ordinary form, there has to be, for instance, a issuing letter to, further down the page, to somebody.
If I
or
could please
collection.
bring you right to those lines,
Yes.
to the agreement on last working day. I really would be grateful for your assistance.
Yes.
With whom is the agreement?
So in the same way
What
that
does it mean by performed by?
in the same way that collection of SBM properties on the 23rd can only be collection from Mr Appadoo, agreement on last working day can only be with Mr Appadoo.
Right.
Nobody else can agree that his last working day can be 23rd of November.
Unless, as my lord says, it was agreed within the HR department that should be his last working day, but not communicated to him.
I can't see that would make any real sense, because there's a number of things that you need to do in order to exit an employee. You need to collect the employee's work equipment. You need to inform the payroll that the employee has departed.
Well, don't you also need to inform the people he's working with on a project, say,
Yes.
and get their agreement so that when he just doesn't turn up to a meeting on the 25th of November, they're not all asking, well, where's he gone? We actually needed him to stay here until that meeting was done.
Yes.
I would have thought you need the agreement of his team.
Well, not agreement, but you need to notify, and that's 2 pages on, my lady, at document D3, which I don't know if we've looked at it already. It's the 395 internal communications sent on Monday the 26th to everybody. Tower users, service units, area leaders, personal bankers, and it advises them of staff departures. And Mr Appadoo is notified to all those people within the bank that has ceased to be an employee of SBM Group, and they're reminded, as per their confidentiality provisions, that the information, non-informational matters, mustn't be communicated with outgoing staff.
Was there any evidence as to what his diary commitments were in that week?
No. No, that wasn't called, and Mr Appadoo didn't give any evidence himself about diary commitments or anything. He just said, when asked,
He just said, I continued working. I continued working. Project, and I continued working. And nobody said from the company, well, actually look at your diary, it shows that all your meetings were cancelled that week.
It could be an agreement also with the person who was engineering a new contract. And so it's agreed that we're going to give him a new contract as from a certain date, and we need a 28-day period. Let's agree that his termination date is on the 24th.
The reason that, my Lord, it must be agreement with Mr Appadoo is that on the all of his colleagues are told that he's left. IT deactivates his emails and his ID. His laptop and his mobile phone are collected. So if he hasn't agreed to the 28-day break in his employment, then it, as a matter of, it would have been, in my submission, absolutely obvious that on this day of the 26th of November, we would have at least some evidence from Mr Appadoo or something that of him coming up to the desk and not being able to get into work, or trying to go to a meeting and not being allowed, or sending an email. There would have been some objection from Mr Appadoo if he hadn't agreed on the 23rd of November to the termination of his employment. There would have been, inevitably have been some objection raised by Mr Appadoo on this week. The idea that he would say absolutely nothing about any of this.
Well, he doesn't remember his, presumably he doesn't, you're right, so the fact that he didn't recall that his ID had not worked or whatever, or had been collected, indicates that it wasn't, doesn't it? Otherwise, he wouldn't have been able to get into the building. He says he doesn't remember all those things being collected.
But
is there any evidence that they're,
what I'm saying, my lady,
checklist, was there any evidence that they all were?
Once, on the 26th, all of his employees are told, you mustn't talk to Mr Appadoo because he's an ex-employee. If Mr Appadoo had then been treated by an ex-employee on the 26th and 27th, 28th and 29th of November without his consent, what I say the industrial court is entirely entitled to infer from this document is that there would have been immediate and strenuous objection by Mr Appadoo to the fact that all of his colleagues have been told that he was no longer an employee when, as soon as he tried to contact any of them, of course, what actually happened is there was no evidence at all of any objection from Mr Appadoo or any attempt to contact employees, which the industrial court was entitled to infer meant, well, Mr Appadoo knew exactly what he had agreed to and what he had to go along with. He agreed on the 23rd to the break of 28 days. He knew that that was what happened to senior executives between contracts as a matter of standard practice. All of his colleagues were told that he was no longer an employee. His was deactivated and so forth. His pay was stopped. He raised no objection to any of this because the only reason why he could have raised no objection to it is because he'd agreed to it. And the Industrial Court was entitled to look at all these points, as they say they did, and take them into account in saying, well, what do we think happened on the 23rd of November? Is it, as Mr Lutchman says, that there was a termination, or is it, as Mr Appadoo says, that there was none of this thing happened at all? And the Industrial Court was, in my submission, the evidence overwhelmingly suggests that Mr Appadoo's evidence was not correct and accurate, and that Mr Lutchman's evidence was. Indeed, in order for Mr Appadoo to succeed in showing that there wasn't a break in his employment on the 23rd, 24th of November, the exit procedure checklist would need to be concocted, would need to be false. That would need to be a document that wasn't true, that wasn't showing a true record of things that were done properly and genuinely, because a letter did have to be sent to all the colleagues saying he was an ex-employee because he was an ex-employee. A letter did have to be sent to IT deactivating him from the system because he didn't require IT access for that 28 days. All of those things that are said in the checklist would have to have been, as Mr Appadoo didn't, through Mr Duval in the event, say that was a false document. But obviously you've seen from the Industrial Court's judgment that a lot of his case was that the bank had acted in bad faith in putting this evidence together. And Mr Duval didn't make any comment or submission at all about how he could have worked during that period when his colleagues had been told he was an ex-employee, or without his laptop or without his mobile phone and so forth. That was just effectively left
Well, you don't challenge his statement that he continued working.
Well, there was a challenge in general terms. If one looks at what Mr Appadoo says in cross-examination, just give me a moment while I find the page in the electronic bundle. We have we look at
when you look at page 395, we wish them all the best in their future endeavours.
Yes.
But they knew that he was going to be back in a month.
Yes.
So what's the point of wishing them all the best in their future endeavours? I mean, were you expecting him to go and get another job? Or did they start recruiting to replace him?
I suspect no and no. I suspect Mr Appadoo is paid at the level that effectively nobody expected him to get alternative employment during those 28 days, although, of course, he'd been entitled strictly to do so. And I suspect that the wording is a standard wording when announcing the exit of employees.
Yeah.
A standard template to say, we wish you all the best, and no more significant than that. But just looking back at what Mr Appadoo's cross-examination, Mr Person starts, you can see that the cross-examination continues at the the bottom of page 197, where Mr Appadoo isn't agreeing with the figure, and the report, document page P19 is produced in the middle of that page. Then at the end of that page, you see document 20 is produced to Mr Appadoo. And then the question is put at the top of page 199, or 4 lines down. My suggestion to you is that as from the 24th of November 2012 until the 26th of December 2012, you were not employed. Your employment had been terminated. And the answer was, I was still working because I was still working because they keep asking. There was negotiations happening on IT contract I was still working. And the next question, my suggestion to you is that during that specific period, and the answer is yes, and that must be the suggestion, must be that during that specific period, his employment had been terminated, as you see from the question just above. So that's Mr Appadoo being directly challenged by Mr Person on whether or not he was employed during that period. If you go down a little further...
Is he drawing a distinction between him still working and being employed? Is that what he's being asked? Yes, you were still working on your negotiations, but somehow you weren't employed by the bank. Is that what's the point that's being made?
Potentially. I don't think I would put... I don't think I would want to draw a distinction that saying Mr Appadoo accepted that he was employed but only said he was working. I think that is Mr Appadoo saying he was employed.
Yes.
That's Mr Appadoo disputing the premise of the question. And the industrial court has evidence from... Well, it sees Mr Appadoo being challenged that his employment had been terminated during that period and has his evidence. And his evidence is only that. And in my submission, that's pretty thin on an employee who comes to court saying, I was employed during that period. If all of the documents attached to the exit checklist were not correct, not true, not genuine, and that he was employed during the whole of that period and there was no agreement to terminate his employment.
Is this exchange during his cross-examination?
Yes, during his cross-examination by Mr Person.
Right.
And you'll see Mr Duval interrupts at that point about the directorship. And Mr Person says it's not disputed he was a director, but he was not employed. Mr Duval says, well...
That's slightly curious, because he's described as a director ex officio, isn't he? So, by virtue of what office?
So by virtue of the office that he had up until the 24th of November and the office that he was then offered on the 12th of December before the appointment was noted on the 13th of December.
Right, so if he were no longer employed after the 24th of November, he wouldn't be an ex officio director, would he?
If he wasn't employed, then his ex officio directorship could be terminated.
I think the trouble with this, if I may say so, is we don't have the constitution of the company, and we don't have the board minutes. It's impossible to get to the bottom of this.
That's true, but
without knowing the legal framework.
But one can perhaps assume this, that when a person stops being an employee, often they then are required to resign as a director if the directorship is held by virtue of being an employee.
Yeah.
But when somebody's employment contract is terminated, unless the Constitution provided specifically, the directorship would also need to be terminated at some point.
I'm not sure. I think there are some old cases about managing directors, that if you're engaged as a managing director and your contract is terminated, you ipso facto cease to be a director as well, because it was only as managing director that you were a director. But I'm not sure. It depends. It all depends on the contract and on the constitution of the company.
That we can look in. It may be that there's a provision in his contract.
It was before the industrial tribe. They took it into account, and they said it didn't get Mr Appadoo home.
Yes.
But we're not. I mean, there are other things here.
Yes, and so looking then at the end of page 199, Mr Person continues at 200. My proposition to Mr Appadoo is very simple. Mr Appadoo has, between the 20... this is argument between Mr Person and Mr Duval, so perhaps we skip past that to when the court effectively gets the exchange between the two counsel finished, and then back to the evidence. It's, I think, 204. And we have at the top of the page, so the only proposition I'm going to make to the witness is that as between the 24th of November 2012 and the 24th of December, my proposition to you is that you were not employed by the bank. And Mr Appadoo's answer is no, I continue to work as an employee. and he said, I put to you that the bank was entitled to terminate. That then comes on to gross misconduct. So that wasn't then pursued. Well, how could you work if you didn't have your laptop, or how could you work if you couldn't get into the building, or didn't all your colleagues refuse to talk to you? None of that was explored. It wasn't, nor was it. I mean, what I say is that the industrial court was entitled on this basis to say, well, Mr Appadoo very straightforwardly could have given evidence in his answers about, well, none of this happened because he was best placed, and indeed he was the plaintiff, to lead any evidence that he had about the fact that it was not correct, that his colleagues had been notified that his employment had been terminated, that it was not correct that he didn't have access to the IT system and so forth. But he said none of that. But I accept, my lady, that these questions weren't forensically put to him point after point either.
And you say they had a binary choice as between his evidence and Mr Lutchman's evidence?
Mr Lutchman said, I've added the word personally. I think it's fair to say that Mr Lutchman was giving evidence about his personal knowledge, because he said, I know, and he wasn't just saying I can see from the documents. I know as effectively the head of HR, or whatever he was, the senior person in HR, I know about Mr Appadoo's case. I know that he was terminated on the 24th of November.
But Mr Lutchman didn't give evidence about whether over the period Mr Appadoo didn't come into the building or cancelled meetings, or he didn't. Mr Lutchman, I don't think, gave evidence about what had happened on the ground, as it were.
No, but Mr Lutchman had given evidence that his pass had been taken away, his access had been taken away, and his ID had been taken away. So in some ways, there's no need for Mr Lutchman to go on. Mr Lutchman had already said that he can't have done anything afterwards, because Mr Lutchman's given evidence that all the things that would allow him access to his colleagues in the building had all been terminated.
Well, unless he comes into the building and somebody comes down to collect him as a visitor, and then he goes up and does his job.
Yes. In that scenario, but anyway, even if you collected the visitor, you would have to have access to the IT system. He's a senior finance officer of a bank. He has to have his laptop. He has to have IT access, and in order to do any work, he can't.
You say that we're entitled to infer, because he'd given up his pass, that he didn't come into the building to work.
Well, strictly no. I don't say that you're entitled to infer.
Or the
I say that the industrial court is entitled
to infer that because they say, which he doesn't remember, he gave up his pass, that must have meant he was unable to work for those days.
Indeed. And the industrial court, in terms, sets out those parts of the evidence as being evidence that suggests the bank's correct that termination happens on the 24th. So the temptation of the Supreme Court to interfere is the ground of my first ground of, in fact, probably all three grounds of appeal, really. And effectively my submission to the board is a reminder of the threshold that we looked at in the authorities about the warnings that appellate courts are given, and what applies to the Supreme Court obviously applies to the board, that due deference has to be given to the court that saw and heard those two witnesses, that heard those two stories. Of course, there's all sorts of things that might have been asked that weren't, all sorts of details that might have been explored, all sorts of things that might have been pleaded in different ways. Effectively, the industrial court had the case in front of it. It had to do the best it could with the evidence it did. But effectively, it was not a difficult decision. Did something happen on the 23rd and 24th of November, as the bank said, or did nothing happen on those days, as Mr Appadoo said? And what the industrial court says, and I don't think I've covered this, this is what is said about the the representative of the defendant company, this is in the industrial court judgment at page 47. And what we see, well, we see, if we go back to page 43, we see the industrial court take into account the claimant's live evidence. Bottom of page 43, the plaintiff denied being aware of the letter sent to Bank of Mauritius and the deactivation of his ID email. When reference was made to the exit procedure checklist, while the plaintiff denied being aware of the document, said document, he confirmed that his laptop and mobile phone were collected from him. Be that as it may, the following documents tend to support the defendant's intention. The plaintiff's employment was terminated on the 24th of November, and then they're listed, and we've already looked at those and gone through those. The following elements, however, tend to support the opposite contention. There's a the date of the Bank of Mauritius one is 26th of November rather than the 24th. The AGM pamphlet, which Mr Appadoo relied on to a large degree in the minutes of those proceedings. The exit procedure checklist said his last working day was the 23rd of November and the date of departure was the 24th of November. The court took that into account as potentially a contradiction. And the email that were dated the 26th of November, that's the Monday afterwards, so that the employees and so forth were told about the departure on the 26th rather than actually on the 24th, which was a Saturday. So the industrial court takes those into account, those two sides. It then, top of page 47, takes into account Mr Lutchman's evidence, because he's the representative of the defendant company. The representative of the defendant company denied having lied or misled either the Bank of Mauritius in document P18 or its shareholders in document P6, as the court would not likely find that the defendant company had lied or misled the Bank of Mauritius or its shareholders, only justified if there was concrete and cogent evidence. There's no such evidence on the record. That being said, whatever may have been the intention of the defendant company as regards offering another contract to the employment after the 24th of November, at no stage of proceedings was any evidence placed on record that in fact put in doubt the authenticity, veracity of the letter to the Bank of Mauritius. So that's the letter in which Mr Appadoo's 28-day termination was notified formally to the regulator. The fact that the letters were addressed to the Bank of Mauritius, which is the regulator of licensed financial institutions carrying on activities in or from within Mauritius, assumes all its importance and therefore prevails over document D5, which is the document which is the minutes of the proceedings, which mentions his reappointment as a director. And then, in light of the above, and regardless of the reasons for such a break, the court is satisfied that there was a break of more than 28 consecutive days in the plaintiff's employment with the defendant company between those dates. The ties of employment between the plaintiff and the defendant company were severed after the 24th of December, and that hence there was no continuity of employment. So that is the finding of fact.
Well, you probably rely on the last few words.
Well, I'm going to come back to that in a moment. So, in fact, we've got a finding of fact that there was a break, and we've got a finding of fact the ties of employment between the plaintiff and the defendant were severed after the 24th of November, and that hence, then we've got the illegal test, there was no continuity of employment. And then, between the defendant company, between the 24th of November and the 24th of December, and that therefore the defendant company has established on the balance of probabilities that the plaintiff's employment was terminated on the 24th. Now,
it doesn't say why it was terminated at all. It doesn't grapple with this concept you're putting forward of mutual agreement at all. There's no factual finding that was a mutual agreement to terminate
But there was a factual finding that there was, in fact, the employment was terminated on the 24th.
Oh, so are you saying that one reads the statutory provision as saying if there's a break of 28 days because of a repudiation by the company of the employment contract, then that is enough to disentitle the employee from relying on continuity of employment?
Well, that must be right. It's a 28-day break of any sort. Of course, it may be that an employee, particularly an employee who's a worker, I don't know about the employee of Mr Appadoo's status, but you could bring an argument to say the contract was not, the repudiation was not accepted, and that the contract thereby continued as an unaccepted repudiation. But if the contract was repudiated on the 24th, then there would have been a 28-day break.
And the repudiation was accepted?
Yes. Yes, if there was an effective...
Like an accepted repudiation.
If there was an effective repudiation,
yes.
if the contract was effectively terminated, in lawfully, by agreement, as we've been discussing, or unlawfully, but an effective termination nonetheless.
But you're saying that it would have had to be accepted, the repudiatory termination would have had to be accepted?
Yes, there's quite some complex case law about the unaccepted repudiation of an employment contract. And in some ways, I was seeking to avoid, I haven't made any submissions on that complex, knotty issue, because I've put my submissions very fairly and squarely, as my Lord has pointed out, on the fact that we do have a tick against there being an acceptance. It may be that I could submit that that's Mr Appadoo accepting a repudiation.
You put it on the basis of mutual agreement.
But I'm putting it on the basis that if there'd been a repudiation, even if accepted repudiation, one would inevitably have seen, in my submission, Mr Appadoo complaining about his repudiation immediately afterwards. In some way, there would have been at least some complaint that he had been treated unfairly or unlawfully in some way. The fact that there's nothing at all, and that Mr Appadoo just goes along with it, is consistent with a agreed mutual termination, and that's, in my submission, absolutely open to the industrial court to infer from what all the material it has in front of it, including weighing up those two banks of evidence that it talks about, and accepting the evidence of Mr Luchman, and taking into account the evidence of Mr Appadoo. Ms Massoud isn't going to have an opportunity to make any submissions to you about the evidence as we've dealt with all of that. Although I haven't dealt with all my submissions, let me just look at whether there's anything else that I was going to comment upon in the... I think that's also covered the matters raised by Mr Duval in his written case as well. I've had a number of questions from the board, but if there are any more...
One more, if I may. In your written case, paragraph 47, it's on page 624. In paragraph 47, the second sentence says the industrial court recorded and accepted the explanation given by SBM's witness that Mr Appadoo ceased employment was because it was standard practice. I've not been able to find that recording and acceptance by the industrial court. I wonder whether you could let me know which you're referring to.
Yes, just... I haven't put a note by my submissions there of the page, so let me just... Actually, perhaps it's more efficient if I stop now, make a note of that, and then I can rise in reply and deal with that. We can hear from Mr Duval if you want to hear from him.
Thank you very much, Mr Burns. I should say we're very sorry not to have heard from Ms Massoud, but you faced some fast bowling this morning. We wanted to be upfront about the problems as we saw them and give you as much time as possible to try to address them.
No.
discuss where we are with this.
Okay.
The court will adjourn for a short time to decide what progress we've made and what we need to hear Mr. Duval on. Well, Mr. Duval, we don't require to hear you on the appeal. We can move directly to the cross appeal.
Thank you, my Lord President. My lords and my ladies, may it please the board. SBM elected unilaterally to file a single written case addressing both the appeal and the cross appeal. Mr. Appadoo was thus deprived of the benefit of a written indication of SBM's position on the specific submission advanced in his written case. A substantive written response to the written case would have provided useful feedback, which would have been of considerable assistance in sharpening the focus of today's hearing. That is an advantage which SBM itself enjoys in relation to its own appeal. In the circumstances, it may assist the board if I address at the outset 4 brief points arising from that part of SBM written case which was devoted to the grounds of a cross appeal. First, SBM relies on the learned magistrate observation at electronic bundle page 61, line 8,
The cross appeal starts on 626.
I'm sorry.
Sorry, go on.
I'm referring to the observation in the judgment, which is at page 61.
Oh, 61, sorry.
Judgment of the Industrial Court.
Yes.
Line 8, and I quote, "There is no prayer in the précipé as regard interest, but learned senior counsel for plaintiff prayed for interest of 12% as provided by section 4611 of the ERA," unquote. SBM suggests that this is a matter of significance. With respect, the position is straightforward. More accurately stated, I articulated in submission Mr. Appadoo's entitlement to interest under section 4611 of the ERA. And I have 4 observations under this point. The first observation is that the record shows how the issue of interest was expressly raised during proceedings. It first arose at the conclusion of Mr. Appadoo's examination in chief. That will be at page 154, line 20, and was thereafter pursued in written submissions, page 285, paragraph 1, and 292, paragraph 50, as well as in oral submission, page 269, line 9. The second observation is that there was at no stage any objection or contrary submission advanced on behalf of SBM. The third observation is that the manner in which the issue was raised and addressed, and the complete absence of challenge for SBM reflects the shared understanding that the application of Section 4611 of the ERA arise in the ordinary course of proceedings before the industrial court once a claim for severance allowance was made. Of course, my friend Bursam and I have a special acceptance of the position because we both appeared in front of the board in the case of United Docks Limited versus Marc de Spéville, where the issue of interest was a part of the appeal, which was rejected by the board. My fourth and last observation is that the only question which arose in appeal before the Supreme Court concerned the manner in which the industrial court exercised its discretion in awarding interest, not the supposed significance of the absence of an express prayer for the exercise of that discretion. If I may now move to my second point. SBM asserts at paragraph 55, and 62 of its written case that the Supreme Court, I quote, allowed the appeal, unquote. While it may be inferred that the Supreme Court did uphold the ground of appeal relating to interest, given that it proceeded to exercise the discretion afresh, the judgment contains no express determination of allowing ground 8 as such. Ground 8 was the only ground of appeal concerning the issue of interest. The position is therefore that the Supreme Court did not make a special finding on the validity of ground 8. It simply reconsidered the matter of interest in the course of disposing of the appeal. Turning to the third point, SBM submits at paragraph 64 of its written case that in this, I quote, that in this appeal, Mr. Appadoo was found to have committed gross misconduct which led to his dismissal, unquote, and that the court was therefore entitled to take that factor into account. With respect, it is not very clear to which appeal we are referring here. In any event, the real motivation behind the decision of SBM to terminate the employment of Mr. Appadoo was not the subject matter of any aspect of the case before the Supreme Court. In fact, the Supreme Court noted in relation to ground 1 that it was irrelevant. At page 65, line 38, the Supreme Court observes that it was agreed that the real motivation behind the termination of Mr. Appadoo was one of the irrelevant matters that the industrial court had considered. That issue became irrelevant by reason of the industrial court rightly finding that the termination was unjustified by reasons of SBM's failure to comply with mandatory provisions of the law. SBM cannot therefore, my lord, my ladies, contend that the Supreme Court was entitled, in the fresh exercise of its discretion, to take into account the alleged misconduct said to have motivated the dismissal, since it itself found that this was irrelevant. That position is inconsistent both with what was agreed before the Supreme Court and with the reasoning upon which the court proceeded. Final, but most certainly the most important point I wish to make is that SBM asserts at paragraph 63 of its written case that the Supreme Court in Ramnaren, which is a decision to be found at page 943, disapproved, that's the word, that Ramnaren disapproved the practice of, I quote, routinely awarding interest simply if claimed, unquote. This is worth repeating. The submission is that Ramnaren disapprove a practice described as, quote, routinely awarding interest simply if claimed, unquote. That submission, my lords, my ladies, does not accurately reflect the decision. The relevant passage is as page 947. I may take my lords and my ladies to page 947. On the top of the page, the court deals with the third ground of appeal, and we read, I quote, "The third and last ground of appeal is the awarding of interest by the learned presiding magistrate from the date of judgment and not from the date of termination of the agreement to the date of payment," unquote. The practice, I suppose, is a reference to what is written in the fourth paragraph. I quote, "Learned senior counsel for the appellant submitted that the cursus was that interest should be granted from the date of termination of the agreement unless there is a reason not to do so. He, however, was unable to establish same or cite any number of decisions," unquote. This is a far cry from a practice of awarding interest if routinely claimed. This refers to a cursus that interest should start being computed from the date of termination. And the Supreme Court says nothing else about this cursus apart from the fact that senior counsel, surprisingly, was unable to provide authority. It is therefore difficult to see, my lords, my ladies, how Ramnaren can be read as disapproving a practice of which the court was not even addressing. I have dealt with the decision of Ramnaren in my written case, and unless the board find it helpful, I don't propose to add to those written observations. But the main observation being that Ramnaren ignores hukum which was good law at the time, and it is simply baffling that senior counsel was not able to refer to Mukun or to WRC, which are both in the bundle, which are both cases which does not only talk about the practice, but where the Supreme Court commends the industrial court for a cursus, a particular cursus.
Which was what?
Which was that interest must be computed as from the date of termination, unless there is a good reason not to, which is the contrary of what Ramnaren finds. Because Ramnaren, instead of looking at established case law, reconsiders the...
But you accept that under the statute, as it currently is, section 4611,
yes,
that the industrial court has a discretion as to the start date for interest, or do you say that because it expressly says that it should be from the date of termination, there is no discretion to start interest running at a later date, which is your...
I believe there is a discretion because what is confirmed by hukum is that unless there is a good reason not to, it should start from termination date. So there is no command, but it starts from termination date. That is a cursus. The provision, the statute provision itself grants a discretion. It's how the Supreme Court said that discretion should be exercised. It's something else. But there is a discretion. And I wish to add that there is something else which seems to be overlooked by Ramnaren, and I mentioned also Guljar in my written case, is that the wording of Section 36(9) of the Labour Act is identical to Section 46(11). So hukum, when it says it should be granted as a matter of course from the date of termination, that was already a discretion. So it is not, my lady, to answer you that the statute commands that it shall be like this. That is what the Supreme Court said.
Section 46, subsection 11 gives a general discretion. What are the factors that are usually taken into account in the exercise of that discretion?
The decision of hukum actually says it does not matter whether the employer is of good faith or not.
What does it
So
say?
that is, WRC say that. If we...
Do you want to just tell us what are the factors before you show us what aren't?
Oh, okay. Well, I believe there are two issues. It's the starting date. So the starting date, there must be a reason not to use the date of termination. And that is, I believe, where the employer is somehow responsible for the delay in which, the delay for the difference between date of termination and date of judgment.
The employee is
The employee.
Yeah.
So a reason for not starting from the date of termination is if the employee is somehow responsible for the delay. And then there is, my lord, the issue of quantum. The maximum is 12%. Now, before the Supreme Court, I suggested that the practice was to grant 12% as a matter of fact. It is when you grant less than 12% that you have to explain.
But I just wanted to have a list of the factors that a court takes into account in exercising its discretion. It's a wide general discretion in the section. And so...
In fact, if I may answer,
one of the factors is whether somebody's been responsible for delay.
We had this issue when we spoke about this matter before this board, for the case of Marc Doge de Spéville and United Docks. And the fact of the matter is that there is no much indication in the case law as to what other factors will be. There were cases where it's stated simply it will be 3%. It does not say why. So we do not have a list of cases which actually list the factors. And I'm afraid that the jurisprudence has not evolved from United Docks to today.
A factor is that the employee is being kept out of his money. That's obviously a factor. Another factor is whether or not the employee or the employer has caused delay or has raised issues that are completely have consumed time and money and dealing with them, are completely unwarranted and so on.
Hukum actually explains that the reason is that Hukum, I insist, deals with computation, the date from which it should start. And Hukum suggests that it is only fair that it should start from date of termination because the employee is deprived of his due. The case of MRC is about, it will be from the date of termination, irrespective of a good faith or otherwise of the employer. So these two cases are only about computation. When it comes to quantum, that is where we don't have much authorities.
And what does it mean by good? Oh, perhaps we'll deal with this later. Yeah.
Yes, I wonder if perhaps, in view of the time, we might adjourn at the moment, and when we resume at 2 o'clock, I think Lady Rose may have a question for you.
I look forward to it.